Alrighty, your favorite auditor, audit them. The one who encourages you to audit them. How many? How many? How many? How many? Them, the one who encourages you to audit them. Oh no. Australia, hello there. Today we are going over the Attorney General Act. Alrighty, so this is about a 11-page read. We're gonna skim through it and see what we have here. Brendan, hello there, long time. And we're gonna create public record requests out of these compiled statutes. Quang, hello there. Before entering 15 ILCS 2051, before entering upon the respective duties of office, the Attorney General shall be commissioned by the Governor and shall take the following oath or affirmation. I solemnly swear or affirm, as the case may be, that I will support the Constitution of the United States and the Constitution of the State of Illinois, and that I will faithfully discharge the duties of the office of Attorney General according to the best of my ability, and shall also execute a bond to the people of the state of Illinois with good and sufficient securities in the penal sum of $10,000 to be approved by the governor, and then filed in the office of the Secretary of State. The bond shall be conditioned upon the faithful discharge of the duties of the office and the paying over all monies as provided by law, which bond shall run to and be for the benefit of the state, county, corporation, or person injured by a breach of any of the conditions thereof. Oh, I like that. Concerned citizen. 2053. Hey Lenny, how's it going? If any person elected to this office or of Attorney General shall fail to give bond or take an oath required of him within 20 days after his declared elected, the office shall be deemed vacant, and if being required to give additional bond as provided in section, he fails to do so within 20 days after notice of such requirement, his office may, in the discretion of the governor, be declared vacant and filed as provided by law. So that's the first request there that we're going to go with. Alrighty, let's see what else we have here. 15 ILCS 2054. The deputies of the Attorney General shall be first to appear for and represent the people of the state before the Supreme Court in all cases in which the state of the people of the state are interested. Second, the institute and prosecute all actions and proceedings in favor of or for the use of the state, which may be necessary in the execution of the duties of any state officer. Third, to defend all actions and proceedings against any state officer in his official capacity in any of the courts of the state or the United States. Oh wow, I like that. So you know what? That's the second request as well. So records here, let's say records of actions and proceedings in regards to any prosecutions against any state officer. Alrighty, so what number is that at? 15 ILCS 205 4 second or third. Alrighty, who's all in the building, guys? Make sure you hit the thumb up. Make sure you leave some feedback in the comment section so we could keep more people coming in here. Alrighty, so there's the other request. Moving forward, to defend all actions and proceedings against any state officer in his official capacity in any court of the state. Okay, 4, to consult with and advise the several state attorneys in matters relating to the duties of their duties, and when in his judgment the interests of the people. X, what up though? The interests of the people of the state requires he shall attend the trial of any party accused of the crime and assist in the prosecution. When the Attorney General has requested in writing that a state's attorneys initiate court proceedings to enforce any provision of the Elections Code or to initiate a criminal prosecution with respect to a violation of the Election Code, and when the state's attorney has declined in writing to initiate those proceedings or prosecutions, or when the state's attorney has neither initiated the proceeding or prosecutions nor responded in writing to the Attorney General within 60 days of the receipt of the request, the Attorney General may, concurrently with or independently of the state's attorney, initiate such proceedings or prosecutions. The Attorney General may investigate and prosecute any violation of the Election Code at the request of the State Board of Election or state's attorney. Fifth, to investigate alleged violations of the statute which the Attorney General has a duty to enforce, and conduct other investigations in connection with assisting in the prosecution of a criminal offense at the request of a state's attorney. That's what it says up here, Rex. Oh yeah, let me know, concerned citizen. You're asking me? I don't, probably because they're, think they have some type of special privilege. It's really just they're ill-informed. So they make stupid decisions, and it happens to be on camera. 6, to consult with and advise the governor other state officers, and give, when requested, written opinions upon all legal or constitutional questions relating to the duties of such officers respectfully. So that's another. So that's another one right there. 6. To consult with, advise the governor and other state officers, and give, when requested, written opinions upon all legal or constitutional questions. So consult with and advise. So here's what we're going to do. Let's say 15 ILCS 205/4. So let's say 4/6. Sixth. Correspondence or any, let's say, records of any consultation or advice between Attorney General and Governor in reference to constitutional questions. And then I'll put C15 ILCS 205/46. So we're going to get a little bit more advanced in the near future. And these are brand new sessions that I'm bringing up and I'm pushing towards the new year. Whereas we read through the Illinois compiled statutes and we come up with FOIA requests based off of what we read. So right here it says records of any consultation or advice between Attorney General and Governor in regards to constitutional questions, let's say from 2018-present. And then we'll say C15 ILCS 205/4 6th. What judges are you referring to that don't have oath of office recorded? Alrighty, moving forward. 7, to prepare when necessary proper drafts for contracts and other writings related to subjects in which the state is interested. This is good shit here. 8, to give written opinions when requested by either branch of General Assembly or any committee thereof upon constitutional or legal questions. 9th, to enforce the proper application of funds appropriated to the public institutions of the state, prosecute breaches of trust, in the administration of such funds, and, when necessary, prosecute corporations for failure or refusal to take their reports required by law. I like that. So let's form up one about number 9. Now they're saying corporations, but are they talking about public corporations or private corporations? Pauly G, long time, Pauly G, long time. So let's go ahead and say records here, records of prosecutions right, yeah, person could be corporation, But in this case, we're going to narrow it down to, we're going to see what they respond with. Records of prosecutions of corporations for breach of trust. Records of prosecution of corporations for breach of trust between 18 present. C, then I'll say C, 15 ILCS 20549. Alrighty. Polly G said he lost his wrench. Nah, Polly G, you haven't been on my channel in a long time. I cleansed all my mods because there was some moderator deleting shit. I'm going to put all the mods back in the near sometime in the near future. I haven't forgot about you, bro. Moving forward, 10th. Yeah, I looked into that stuff with some stuff here and there, Kevin. 10th, to keep a register of all cases prosecuted or defended by him in behalf of the state or its officers, and of all proceedings had in relation thereto, and to deliver the same to his successor in office. I like that one too. 11th, to keep on file in his office a copy of the official opinions issued by the Attorney General and deliver to his successor. 12th, to pay into the state treasury all monies received by him for the use of the state. 13, to attend to and perform any other duty which may from time to time be required by him by law. 14th, to attend, present evidence to, and prosecute indictments returned by statewide grand jury. 15, to give written, binding, and advisory public access opinions as provided in Section 7 of this Act. That's the one I know of for a fact, that they do offer those packets of opinions, and that's talked about in the FOIA Act as well. Right, and that too, yeah, bootlicker, right now that nobody could delete shit, you know what I'm saying? And then not only that, somebody's just a mod on live when you're going live, they're also a mod to all your content and in your entire channel. They could delete any comment that they want to. So I'm not with that, you know. I gotta, you know, slowly but surely, I'm gonna tack that option back on. Okay, Section 4A, attorneys and investigators appointed by the Attorney General and on his payroll when authorized by the Attorney General or his designee may expend such sums as the Attorney General or his designee deems necessary for the purchase of items for evidence, the advancements of fees in cases before the United States courts or other Supreme Courts, and in the payment of witness or subpoena fees. Oh, Kevin, salute to you, salute to you. Are you an esquire or you just been doing your own homework? Checks and balances. Alrighty. Funds for making expenditures authorized in this section shall be advanced from funds appropriated, made available by law for the support or use of the office of Attorney General, or vouchers thereof signed by the Attorney General or his designee. Sums so advanced may be paid to the attorney or investigator authorized to receive the advancement, or may be made payable to the ultimate recipient. Any expenditure under this section shall be audited by the Auditor General as part of any mandated audit conducted in compliance with Section 3.2 of the Illinois State Auditing Act. We're going to look that up at a later time. Press, hello there. 15 ILCS 2054B. Before the filing of the first pleading in federal district court in any civil action brought by the Attorney General in the name of the state as parens patriae on behalf of the natural persons residing in the state, as authorized by Section 4C of the Clayton Act, 15 U.S.C.A. 15C, the Attorney General shall file with the Auditor General a statement disclosing the fee arrangements applicable to the attorney's fees in relation to that civil action. That's another good one right there, too. Yeah, that's a good one, Kevin. All of that is null and void. The thing I love about statutes is it outlines the obligations of the employees. And that's where we come in and audit them through the FOIA Act. So were you an attorney, Kevin, or you just did your own homework? Section 205-4C. Subject to the qualifications set forth below, investigators employed by the Attorney General shall be peace officers and shall have all the powers possessed by policemen in cities and by sheriffs, provided the Attorney General's investigators may exercise such powers anywhere in the state and cooperation with and after contact with the local law enforcement officials. So they got their own uniform. No investigator employed by the Attorney General shall have peace officer status or exercise police powers unless he or she successfully completes a basic police training course mandated and approved by the Illinois Law Enforcement Training Standards Board, or such board waives the training requirement by reason of the investigator's prior law enforcement experience or training, or both. The board shall not waive the training requirements unless the investigator has a minimum of 5-year experience as a sworn officer of law. State or federal law enforcement agencies shall have been, or two of which shall been the investigator capacity. The Attorney General must authorize to each investigator employed under this section exercising the power of a police officer a distinct badge that on its face clearly states that it is authorized by the office of the Attorney General. Number 2, contains a unique identifying number. I like that. No other badge shall be authorized by the Attorney General. Locating support obligator at 4D, 205-4D. The Attorney General may request and receive from employers, labor units, telephone companies, and utility companies location information concerning putative fathers and non-custodial parents for the purpose of establishing a child's parental or parenting, or establishing, enforcing, or modifying a child support obligation. Oh wow, they're able to contact your whole ship In this section, location information means information about the physical whereabouts of a father or non-custodial parent. They put a GPS on you. They're allowed to, according to this code. The salary, wages, and other compensation, yada yada. Section 6. Section 6. Whether the Attorney General is sick or absent or unable to attend or is interested in any cause or proceeding, civil or criminal, which it is or may be his duty to prosecute or defend, the court in which said cause or proceeding is pending may appoint some competent attorney to prosecute or defend such cause of proceeding, and the attorney so appointed shall have the same power as the attorney in relation to such cause or proceeding as the Attorney General would have had in presence in attending the same. Alrighty. We're not going to spend too much time on this stream, guys. I just wanted to come in real quick and go over some basic things right here. We're going to leave it at 6.3 for today. 15 ILCS 20563. We may continue this a little later on tonight. Or we might go into an additional packet. However, I'd like to thank everybody for coming in today. So we'll be back on duty. Stay tuned for new content is coming as well. The one who encourages you to audit them.